Completion stage. This is the stage where the parties to transaction conclude all processes that vest the legal title on the purchaser. The following usually signifies completion: A. Payment of the balance of the purchase price. B. Signing of the formal conveyance by the parties. C. Handing over of the title deed and other documents by the vendor to the purchaser. D. Taking over possession of the property by the purchaser, either actual or constructive. E. Vesting of legal estate in the purchaser. There may be circumstances where the vendor does not hand over the title documents to the purchaser. Where this is the case, it is to be endorsed on the agreement that the vendor is with the title document, and also necessary to insert a covenant to produce the title document in the deed of conveyance. Completion statement. This is otherwise referred to as financial statement. It is prepared by solicitors involved in a sale of property. This is a statement of the financial commitment of the parties and any financial obligation expected to be met towards the successful completion of the transaction. Advantages of serving completion statement. It helps the seller to decide whether to sell with regard to the expenses to be incurred or to suspend sale until property appreciates in value. B. It helps the purchaser calculate his financial obligations to know whether he can continue with the transaction. C. It helps in accountability and reduces chances of fraud being perpetrated on the client. D. It also helps in the computation of taxes. Post-completion matters perfection. Application for governor's consent. Where property is subject to the customary right of occupancy, the consent required is that of the local government where the land is located. Section 21 of the Land Use Act. Governor's consent is usually to be sought and obtained by the purchaser solicitor. Ideally, it is the vendor who should apply for and obtain the governor's consent. The purchaser should thus ensure that he obtains a letter of application for consent from the vendor. The solicitor may write a covering letter forwarding the vendor's letter. Procedure for the application of consent. A. Write an application to the Ministry of Land in the state where the land is situated, and B. Attach current tax clearance certificate of the assignee or assignee for a period not less than 3 years. C. Ensure that a certified true copy of the title document is duly attached. D. Also attach a copy of the deed executed with respect to the property. E. Attach evidence of payment of ground rent. F. Attach evidence of payment of tenement to it if the property is already developed. G. Attach copy of approved building plan. H. For a company, evidence of remittance of current pay-as-you-earn of its staff to the state government. I. For companies resident outside the state, tax clearance certificates of 2 directors of the company should also be attached. Procedure for applying for consent in Abuja. A written application to the Minister of the Federal Capital Territory. B. An inspection and valuation is conducted on the land. C. Consent fee and other outstanding rents and charges on the property is paid. D. Tax clearance certificate for 3 years preceding the year of the transaction. E. You may pay title regularization fee if you are not the direct owner of the property. F. Produce original of title documents for citing and the counterparts for company. G. Attach Form CAC7 as well as memorandum and articles of association. Stamping of deed. This is compulsory and it is usually done after the governor's consent is obtained. Some documents attract stamp duty on flat rate basis. A perfect example is a contract for the sale of land. Others attract ad valorem duty. Where the transaction is chargeable ad valorem, stamp duty must be paid within 30 days of the execution of the deed. Section 23 sub 3A Stamp Duties Act. Effect of failure to pay stamp duty. It makes the document non-registrable. It makes the document inadmissible in evidence. Section 22 of the Stamp Duties Act. Ogbaon and Registered Trustees 2001. Federation Weekly Law Report Part 80 1496. Procedure for the payment of stamp duty. The solicitor presents the original and copies of the instrument for the stamp duty office to assess the duty payable. Assessment is made based on the value of the transaction in the instrument, and the assessed duty is duly paid at the designated bank. The instrument is impressed to the stamp of the body of internal revenue as evidence of payment of the duty. Registration. A deed must be registered within 60 days of the date of execution of the deed. Importance of registering documents. 1. It is an indication that the title of the property is encumbered. 2. It gives priority to the instrument registered at the first time. Effects of non-registration. A. It cannot be pleaded. B. It is inadmissible in evidence. Procedure for the registration of deeds. A. Forward the original and the counterpart of the duly executed and stamped deeds to the registrar of deeds. B. The registrar collects the deed and registers in the register of deeds on a particular volume, page, and number, e.g., number dash at page dash in volume dash. The original deed is given back to the purchaser while the counterpart is kept at the registry. Here is a sample draft of a search report. Note that where more than one search report is involved, then a cover letter is drafted and search reports are attached, including the bill of charges.